Contract law, part 1. Contract law is actually a very simple concept to understand. It is the basic of living in this world, doing activities, interacting with other parties or people in whom you may want to do business with, doing transaction with, or any transaction that you may wish to perform with other people. Basically, contract law has only 7 items, which are the offer between two parties, between another person. Contract laws cannot work on its own. It has to be interacting with another group of people or other people. So you need to have, first of all, an offer. You offer to somebody something, an action to be done later, an act to be done later, a work to be done later, some sort of performance to be done. Then that offer has to be accepted by the other party or the other person. Now, between, let's say, there are two group of people or two group of persons or two persons, a person A and a person B. A is the originating person and B is the receiving person. Now, if you have an idea, you have a transaction, you have a business, a work to be done, a performance to be done, you offer to B. A offer to B. Now, it is only a unilateral, one way from A to B. That offer has to be communicated to B. Now, then B would then has the right to reject or accept the offer. Now, before that can happen, that information, that offer must be written on paper, transcribed on some sort of media to be sent to B. It could be either in paper, through a post office, through a postman, or it can be through a telemedia, which is in the modern world. You have many forms of transmissions, some of which are accepted and others may not be accepted. Now, first of all, the offer, it's been communicated to the offeree, and the offeree would then accept. Now, in commercial world, nothing it's free, nothing is done without any benefit. A offering to B, B accepting the offer from A through a communication media, channels of communication. Therefore, there must be a benefit for both A and B. Generally, in contract law, it is used, utilized in business, commercial world, which therefore requires a benefit for both A and B. That kind of benefit is considered consideration. Now, a consideration can be in kind, can be in value, but not necessarily in a full value of the amount or the value of the work performance. It can be as low as a kind of any form of benefits, sometimes to the benefit of so little that it is reasonable to accept. Now, that is called consideration, a benefit in kind or benefit in value, but not necessarily reflecting the actual value of the products or the performance. Now, next we talk about, if you say offer acceptance, communication to the media, through the media, by post, by paper, by written forms, or by even words of mouth through a friend, or to a messenger, for example, riding on a horse, from A offering to B the information through a messenger riding on a horse. Now, in all circumstances, you may consider that if there is a breach, right, there are some things that's supposed to be performed, and it's not done, then what recourse can you take? Who can you bring it up to? So first of all, in order to have a law of contract to come into place, you must have an intention to create legal relation. Now, a legal relation, therefore, you can submit to somebody higher, to be a judge, to be a arbitrator, or to somebody who actually can be a judge to say who is right and who is wrong and what should be done. So therefore, you must have an intention to create legal relation. But sometimes in the law of a nation, public perceptions is very important. A public view, things that have no public or public effects. For example, if a person is underage, you have certain things that certain person can do. For example, to buy a cigarette, to buy a bottle of liquor. Now, a person has to attain a certain age, taking a driving license, for example, because a person under a certain age, psychologically in a state, is considered not matured yet, not adult. So the thinking, the forms, mind may not be of a certain standard. Therefore, we say there is a capacity to it. So the person must attain capacity as to the age in order to transact a contract. Now, a capacity may not be actually the age of a person. For example, a company A and company B, right? In order for company A to make a transaction with company B on a business commercial decision, has to be a person of a capacity in company A to a capacity in company B. In other words, the person who is going to say yes or no, or to accept the offer or to giving the offer, right, has to be a certain capacity in a company. So the capacity is actually a very wide definition of capacity. Now, in all these acts, there are in public laws certain activities considered legal and certain activities are considered illegal. What is illegal and what is legal? Those are the act or activities properly defined in the constitution or the statute of a country. For example, in certain country, you cannot drink alcohol. Maybe a Muslim country, you cannot drink alcohol. It is illegal to purchase and to consume alcohol. But outbound to a European country, for example, which are not certain reasons, for example, in England, you can drink alcohol, you can buy alcohol, but you have a certain time limit up to maybe 11 p.m. at night. So it is legal until 11 p.m. to buy and drink alcohol in the public, but not public as in outside public, in a pub, for example, licensed places. Now, so that is legal or illegality. So, however, having said that, of the 7 items in contract law, which is offer, communication of the offer, acceptance of the offer, consideration, intention to create legal relation, capacity, and illegality or legality. It is very straightforward, only 7 items. However, you may also see a deviations. There are deviations. Sometimes, in life, it is not always smooth sailing. We say there are 7 items, but how about certain events that happened in between when you really want to, for example, giving an offer to a other party to accept your offer. However, circumstances beyond your control or within your control comes into play and causing a deviation in that planned activities that you're trying to do. For example, in a commercial decision, you want to sell something to A to B, but however, there are certain concern. Goods never arrive because goods has to be shipped from another port to another place, and something happens, in transit, rough seas, weather. Sometimes even you communicate, you tell another person, speaking to another person, A speaks to B, and there's an aeroplane flying which join the voice between A and B. Now, so if there are deviations, what happens to those deviations? We have come across that we want to have an intention to create legal relations. So when you create legal relation, such deviations are challenged in courts. So when those deviations are challenged in courts, then the judgment from the judges in a court, having said that as a precedent, means it happened before, and therefore we shall take that the decision made by the judges as a rule to be applied and to be followed in subsequent same case deviations. Now, why are that so? Now, this is very common in a common law country. For example, in Britain, Commonwealth country, and Singapore, and Malaysia, in Pakistan, in Hong Kong, and many other countries that were once from a colony or from a British Commonwealth country. They follow precedents, rules of precedents, common law precedents, which is called stare decisis. Now, we will then follow, this is part 1 of the lesson, we will then follow with part 2, part 3 and so forth, and we will study the exception rule, we apply the rule of precedent, alright, and we must know in contract law there is both way, unilateral or multilateral. It cannot be by yourself, dealing with yourself. It has to be communicated, right? And therefore we will end this part 1 and we will continue with part 2.